Thank you so much, Mr. Clerk. Madam Chair, your first testifier and only testifier here in the Hilo chambers is Mr. Russell Ruderman. Mr. Ruderman, if you could just unmute the mic by pressing the button at the bottom of the mic, you'll have 3 minutes to provide your testimony from your start.
Thank you. Aloha. Thanks for hearing my testimony. My name is Russell Ruderman. I'm here as the owner of Island Naturals Markets, a group of grocery stores on the Big Island. Aloha and good morning, Chair David and council members. Thank you for allowing this input. I'm here to discuss Bill 220, and I'm urging you to make further amendments to it. My particular amendment has to do with businesses that are open to the public, which ought not to be places where private firearms can be carried. And at the very least, I'm urging you to allow such businesses, any business, to post a sign saying private firearm carry is not allowed in here, and let that be legally binding. Another way you might look at it, if you feel you don't have the right to do that, is to say private firearm carry is only allowed if that business welcomes it by such a sign. I don't think it should be allowed. I mean, we're protecting kids in parks and schools. Well, there's kids in the grocery store too. Grocery stores are an essential service. People need to go get food. It's not an option, and we need to keep folks safe. I'm not anti-gun. I'm a gun owner myself, but I'm pro-safety, and I think that comes first. In 23 years of doing business, no one has needed a gun in any of our grocery stores so far. I fear that will change with the laws you're about to pass. By the way, I'd like to remind you folks that I don't come down here and bother you very much. You know, it's pretty rare, and this is really important to me. And although there's not a lot of business owners here talking about this, most of them aren't aware of it. So I speak for a lot of other people who have to keep a public retail space safe, who have no idea that this discussion is going on. I've given you a plethora of testimony. I trust you've all read it. I want to particularly describe to you the scenario when someone comes into our store with a gun. If we're aware of that gun, I'm talking about private citizens. I mean, police officers are welcome in our store. In fact, we have a standing offer of free coffee for any police officer that comes in. Private citizen comes into our store with a gun. Is that 1 minute already?
30 seconds, please.
30 seconds. Okay. We're not going to serve that person. I'll fight it out in court whether I'm required to. I believe I have the right to refuse service. And that person's going to come in there and say they have the right to be there. And it's going to be a standoff with an armed civilian against untrained private citizens with kids and grocery shoppers, you know, and in the worst situation, if someone ever does hold up our store and such a person feels they want to be a hero, then you have crossfire in a private situation. Please amend this bill to allow public places of businesses to refuse to allow private firearm carry. I'm available for questions. I'm happy to come back at the time of the agenda item if anyone does have any requests.
I'm sorry, Mr. Ruderman, but we're going to have to move on.
Good morning, Council. Todd Yukutaka, representing the Hawaii Farms Coalition, and we oppose Bill 220. Since the last hearing in the New York Antonyuk versus Hocho lawsuit regarding sensitive places, the TRO was replaced with a preliminary injunction, so that lawsuit is continuing to move forward. And their sensitive places law is similar to Bill 220. Our recommendation is to wait for the state legislature to determine sensitive places to avoid legal liability for the county and have a standard across Hawaii that prevents confusion. Please read my testimony for my suggested amendments. The new ban on carry in restaurants that sell alcohol is unreasonable, as many restaurants primarily sell food and not alcohol. They just sell alcohol on the side. One example is I go to Kuhio Grill in Hilo, right across the street from the county building to eat. And I've never drank any alcohol there. I've never ordered a beer or anything. I just eat the good food over there. There's already a prohibition in Bill 220 on drinking while carrying. So a ban in restaurants is not needed. Or you can perhaps compromise would be you could ban alcohol in basically just pure bars that mostly sell alcohol. The ban on carry on public transportation hurts those that need it the most. People use the bus to go to remote areas and walk around at night. There's also been attacks by wild boars and vicious dogs that's been in the news on the Big Island. Many of these occur where police response times are poor, so it's up to a person to protect themselves. So they need a firearm to protect themselves. And some government officials may need to carry too, perhaps yourselves one day, to protect against death threats. Judges, legislators, again, maybe yourselves have been threatened in the past and maybe in the future. Your former House representative, Tulsi Gabbard, sought a CCW permit to protect herself against a stalker and death threats. So it's not just the people. Government officials are threatened all the time too, and may need that protection
30 seconds,
themselves.
please. 30 seconds.
During the last session, it was mentioned that people with firearms don't prevent crime. There are millions of defensive uses of firearms each year. Most of the time, it's not reported in the news because a crime that didn't happen isn't reported or newsworthy. A few examples: the Greenwood Mall shooting, where a private gun owner stopped an active shooter in the shopping mall. That mall prohibited the carry of guns, so he actually did illegally, but you probably would have still wanted him to be there. In 2019, Eva
I'm
Beach
sorry, Mr.
neighborhood.
Yukutake, but your 3 minutes are up and we're going to have to move on.
Okay, thank you for hearing my testimony. Again, please oppose Bill 220.
Hello, how you doing? My name's Dan Petty. I'm up from Mountain View. I'm against this 220. I think it's against our Constitution. I have taken an oath, and I believe that all of you have done the same to support and defend the Constitution against all enemies, both foreign and domestic. This is one way of trying to take away our rights by telling us where we can and where we cannot go with weapons. The Supreme Court basically just threw all these out, and they're going to do the same thing. You guys are going to keep trying to nickel and dime everything, trying to get everything taken away from us. It's going to go to court, and you're going to find out that it's probably going to be thrown out again. Okay. Every time you guys try to do something, there's always somebody out there who wants to take away our rights somehow. And the purpose of the First and Second Amendments, we have the right to freedom of speech. And the second thing they told you was get a gun. So basically, whether you want to believe that or not, that's up to you. But we have our laws are based on the Constitution, and therefore we should have the right to carry and protect and defend ourselves, our families. We all have that right. Whether you believe in that or not, that's up to you. But that's part of the Constitution. Any other questions? Any questions for me or? Okay. All right. That's fine. Thank you.
Madam Chair, your last testifier for this item in Hilo Chambers is Mr. Brian Lay. Brian, if you'll unmute the mic by pressing the button at the bottom of the mic, you'll have 3 minutes to provide your testimony.
Hey, Brian Lay, I want to thank the officer and back for being here again. It's kind of a little hypocritical. Every time I come here, we have a gun in a public building, but here or there. And somebody at the council, that last thing, he says, what did we say about the society? The last numbers for 2019, the crime for Hawaii alone, violent crimes, 4,042, property, 40,226, murder, 48, rape, 765, robbery, 1,131, aggravated assault, 2,098, burglary, 5,340, larceny, 29,634, and vehicle theft, 5,254. This is the society we live in. This is why we want concealed carry. This is why we want to carry it wherever. 80% of the time that a gun is used to protect people, 80% of the time the trigger is never pulled. I speak from experience that just showing a gun will diffuse a thing. And those are crimes that are never committed, because I don't call the police and say, I just pulled a gun and the guy ran off. That doesn't happen. So we have no idea how many lives or people going to the hospital for being violently beaten, which seems to be ongoing right now. And, We all defend the right of a woman to get an abortion if it interferes with the health of her. Why can't we have the same rights? You guys should be fighting for the same rights as a woman to abort her child because it could interfere with her health and well-being. That's the same right that I would like. I want to protect my right to protect myself. You know, 220 is a horrible written. I mean, from the get-go, it just went into federal court, overturned it, said a bunch of the stuff is unconstitutional. The last meeting I was here, Aaron Chong was questioning the corporate counsel on misinterpretation, to put it nicely, on things that she was saying was legit. So we've got a bill that has just been poor written, already in court system and everything else. Like Todd said, this just needs to be chambered. You know, let's get a resolve. What are the courts saying? You know, we've got constitutional rights. You know, I took the same oath as you guys did when I became a GMAC commissioner. And that's why I'm here today, is because I believe in that oath and I'm following through on my oath. I have better things to do than come here 3 times and discuss these things. You know, it's a beautiful day.
30 seconds, please.
All right, thank you. And, you know, and I've only heard one person say they've been in favor of this bill. 3 times I've been here, all the testimony has been against this bill. Only one person has been in favor of that. So we need to take that in consideration. The population and the public is against this bill. So thank you very much.
Up for second and final reading, Bill 220 Draft 3, which amends Chapter 14 Hawaiʻi County Code 1983, 2016 edition, as amended by adding a new article relating to licenses to carry concealed and unconcealed firearms within the county. Establishes a new article that includes certain sensitive places where the licensed carrying of a firearm would not be allowed, certain other sensitive places where the licensed carrying of a firearm is only allowed if authorized by the operative facility, that the licensed carry of a firearm while intoxicated is prohibited, that upon contact with law enforcement, the licensee must notify the enforcement officer of the possession of a licensed firearm and present their license for inspection, and that a license may be revoked by the chief of police for 1 year for any violation of the terms of this new article. Introduced Mr. Chung. First reading was number 2, 2022.
Mr. Chung.
Move to approve.
Moved by Mr. Chung, seconded by Mr. Inaba. Go ahead, Mr. Chung.
Well, I see some amendments, so why don't we just address those?
Thank you. Ms. Kimball?
Thank you, Chair. And let me just say once again, thank you, Mr. Chung, for introducing this really important bill. We've had lengthy discussions around it to date. I did have a couple additional amendments, things that were still kind of unclear in my mind or needed additional consideration. I'd like to start, if I may, with communication 1022.131. So motion to amend Bill 220 Draft 3 with the contents of communication 1022.131.
Is there a second? Moved by Ms. Kimball, seconded by Mr. Inaba to amend Bill 220 Draft 3 with the contents of communication 1022.131. Go ahead, Ms. Kimball.
Thank you. And I think this is an example of where simplicity actually is the solution. I went through a couple of different drafts here with Corporation Counsel, and I believe Deputy Juan is present in the Hilo chambers if you have questions for her. But there was some lack of clarity around this permission granting. And as I was trying to work around some mechanism to notify public about this, Deputy Juan clarified for me that this language, that the exemption where the permission is granted to an individual, not to the general public. And so that's a very simple addition for clarity of language, that these administrators of these institutions will give an individual permission and not just blanket permission. I think that was also your intention when you added the exemption, Councilmember Chung, but I just feel like for the public's understanding and transparency that wording should be added to the bill. Thank you, Chair.
Thank you, Ms. Kimball. Anyone else? Mr. Inaba.
Yeah, Deputy Juan, just language-wise, when we're adding the term "to such person," because there's not a reference person prior to this language, we're indicating that the administrator could grant permission to any one person or whoever they grant permission to. I'm reading it, I think, a little strange in my head.
Chair, may I respond?
Thank you. Ms. Kimball, go ahead.
Yeah, just, it's meant to be read in context with line A. So any person granted a license to carry, blah, 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 except where permission is granted to such person. So that is the person that is being referenced in the item 1, A1 and A2 and A3.
Got it. I understand. Thank you.
Thank you, Mr. Inaba. Anyone else? Seeing none. All those in favor of approving Bill 220 Draft 3 with the contents of Communication 1022.131, please say aye.
Aye.
Any opposed? We have 6 ayes, Mr. Clerk, on the amendment, and Ms. Villegas and Ms. Leloy are excused. Ms. Kimball.
Yes, Chair,
Before you
thank you.
proceed, just procedurally, normally the council would make a motion to suspend its rules if this is up
Thank
for
you.
second and final reading, but I will note that the rules specifically state that if a bill up for final reading, paraphrasing, should not be acted upon at the time of the floor amendment, final action should not be taken into the next regular meeting. So that if there are additional amendments, that could be interpreted to mean that as long as the council doesn't vote on this today without suspending its rules, then further amendments could be
Can be
considered.
made.
So
Okay.
if that's more efficient and the council
think so.
believes that's in alignment with the rules, you may proceed.
Thank you. We'll take care of all the amendments first, and then we can suspend it when we're at the final. Thank you. Go ahead, Ms. Kimball.
Thank you, Chair. Motion to amend Bill 220 Draft 3 with the contents of Communication 1022.130.
Second.
Moved by Ms. Kimball, seconded by Mr. Inaba, to amend Bill 220 Draft 3 with the contents of Communication 1022.130.
Thank you,
Go ahead.
Chair. This is another attempt to find some language that could provide compromise and or a compromise solution from a position that I was holding with the rest of the body's position. And, you know, a lot of the conversation we've had has been about individual liberties and preferences. And, you know, we allow for people to say an event is drug and alcohol free, as an example, or a smoke-free event. And so what I wanted to just make sure we codified in here was some language that allowed the organizers of an event to indicate that their event was a concealed carry prohibited event or something of that nature. Again, you know, with the conversation that happened from some of the testifiers today, this isn't about one civil liberty that's guaranteed by the Constitution overriding other civil liberties that are guaranteed by the Constitution. It's finding that balance. And so I'm hoping that my colleagues can agree that this amendment provides that balance. It is not a broad prohibition, but it does give the organizers of the events the right to say the nature, the condition that they want their event to have. Again, something very similar to saying drug and alcohol-free event. Thank you, Chair. I yield.
Thank you, Ms. Kimball. Anyone else? Seeing none, all those in favor of approving the amendment to Bill 220 Draft 3 with the contents of Communication 1022.130, please say aye. Any opposed? We have 6 ayes, Mr. Clerk, and 2 excused, Ms. Villegas and Ms. Leloy. Thank you, Ms. Kimball.
Thank you, Chair. One final amendment here. So motion to approve or amend Bill 220 Draft 3 with the contents of 1022.132.
Second.
Moved by Ms. Kimball, seconded by Mr. Inaba to amend Bill 220 Draft 3 with the contents of Communication 1022.132. Go ahead, Ms. Kimball.
Thank you, Chair. This again is in response to some of the concerns of my colleagues, as well as help providing some clarity about what we mean when we talk about property that's open to the public. I mentioned in our previous discussions that we now have defined in the zoning code what is considered places of public accommodation. So I've added that reference in there. Some of the locations that are listed in previous components of the bill, like the hospitals and the schools and things like that, are already dealt with. So this is other places of accommodation. So these are businesses, hotels, things like that. Please refer to that section of the code for the descriptions of that. There was the concern from former council member now, Richards, about the how it would apply to agricultural property. So, you know, I didn't have any concerns particularly about that. So I made an exemption for that here. The main thing, in addition to those two items, which I think are there to provide clarity, is I just want to go back to this idea, and former Senator Ruderman kind of touched upon this, is that we have historically not been a state where concealed carry is allowed. And a lot of business owners still don't know that we're even discussing this right now. And what I'm concerned about is that we have kind of an established understanding already out in the general public and on private properties that they're not permitted. We're going to go ahead and, you know, allow for individual private property owners and places of public accommodation to permit them. And until such time as this is kind of widely known, I think it's important to have a proactive alert to the public rather than the contrary one, just because of the inherent assumptions that I think are going to be made by the public. And so again, this is shifting the notice from, rather than having signage not permitted, to having signage that it is permitted on those places of public accommodations. Again, I think it's just, we're in this transitional period. The understanding has always been not permitted. I think if we do a 180 so quickly, it's going to cause a lot of confusion and disruption. So my preference, again, is to have the alert be when it is permitted on these private places of public accommodation. Thank you, Chair. I yield.
Thank you, Ms. Kimball. Mr. Chung.
Yeah, thank you. You know, first of all, I wanted to really credit Councilmember Kimball for her persistence, even tenacity, you know, on trying to, you know, get a better bill together. This is kind of clever, you know, how she's bringing this in, because this is actually, you know, one component of it was actually what she had, you know, made a motion on the last time, but she also added a new clause relating to that concern that former council member Tim Richards had brought up. And, you know, this is something that I've been going back and forth on, you know, even while I'm at home, just thinking, well, what, you know, where should the burden lie? And I'll say right now, though, you know, I am of the belief that this is probably a more sensible way of going, you know, given, you know, how our community sensibilities have been over these many years. So I'll be supporting this.
And I really do feel, and we've had a lot of discussion about this bill. And I'm not a huge proponent of guns. Okay, I have a gun, but I don't want everybody running with guns in their back pockets. But we're discussing a Supreme Court ruling and the allowances of that ruling. And the farther we've gotten into this bill, the more we have just started to, it's like almost like you give an inch, you take a mile. I'm looking at the section 25-1-5 or Hawaiʻi County Code at the places of public accommodation, and it's starting to get absolutely redundant. (25-1-5)(6) has motion picture theaters, auditoriums, convention centers, lecture halls, concert halls, sports arenas, stadium, other places of exhibition or entertainment. And we are being asked in a previous amendment today, the as adopted amendment 1022.130, places where people are assembled for an event, social gathering, rally, demonstration, or public exhibition. And it's just, to me, this amendment is getting almost to the point of absurdity. I understand the reasoning behind it, and I know the introducer is very adamant about this. But it's redundant. I would say you pick places of public accommodation and then revisit these sections where you've already, like, bars, restaurants, that's under the same section. Places of exhibition, it's under the same section. Restaurants, cafeterias, under the same section. I mean, it may be better to go back and revisit this instead of just adding. I just think that it's getting a little absurd at this point. That's my 2 cents.
Chair, if I may respond.
Go ahead, Ms. Kimball.
Thank you. I wanted to just clarify a couple of things, and there's a very important clause in this amendment. So we have places of public accommodations defined in the code other than those listed in this section. So I did appreciate that some of the locations that are listed under places of public accommodation in Chapter 25 have already been dealt with in other sections of this particular bill. And so it is I did not want to introduce redundancy, and that's why those are excluded. The other thing I think is really important to note is that the previous language was private property open to the public. All of those things that are listed under places of public accommodation are exactly that. The difference is that there's clarity in Chapter 25 about what open to the public means. And so again, this amendment is to provide clarity and transparency around the definition of what is open to the public, what is a place of public accommodation, and that clause about excluding those that are otherwise listed in this section is intended not to create duplication. So appreciate the concerns, but I think that with careful reading here, the intention is to just really make sure our language is concise and referencing the other relevant bits of the code. Happy to answer any further questions on the intent behind that wording change. Thank you, Chair.
Thank you, Ms. Kimball. Anyone else?
Chair.
Go
I think
ahead,
I still have
Mr.
the floor. Thank you.
Yes, go ahead.
And then as far as switching the wording from, this is more of a question for Corporation Council at this point. So as I'm reading this new proposed language in number 7 in the amendment on 1022.132, we're moving towards what I see as the opposite of what the Supreme Court ruling was, where unless it's posted that you're allowed to have, you can't carry.
Deputy Corporation Counsel Sylvia Wan. So when it comes to private property, there is a fundamental right with private property to decide whether or not firearms can be on the private property. It is true that these are, what we're talking about here are private properties that have opened their doors to the public. So what you're looking at is a battle between two different fundamental rights coming up against each other. And in that particular instance, the one cannot assume the other, right? So a person who wants to have their firearm on public property is not going to be able to, on private property, will not be able to do that if the private property owner does not want to allow it. So this particular provision, whether it's posted, whether it's allowed or not allowed, has been done in both different ways in the various states. So this is really just a matter for this body to determine which way do they want it to be within our community.
I guess what I would rather see, this is to the general, both Corporation Council and the maker of these amendments, is, and this is coming from as a business owner. If you don't want them on your property, then you put up a sign and say it's prohibited. Otherwise, we're following the law, and you can carry as it's been allowed in our state. By doing this, I now, as a business owner, and any business owner in our state, or sorry, in our county, is gonna have to put up a sign saying not permitted. Sorry, and I may be saying this wrong because it's a little bit confusing. Yeah, we're gonna have to put up a sign saying the opposite. So you're putting the responsibility on the business owner. And I already have to post 1,000 signs, you know, the Department of Labor stuff and all these different signs and this and that and this and that. Okay. Now I got to go do one more sign saying that I want to get this right. I am allowing or I'm not allowing.
Deputy Corporation Counsel V1. So as far as the amendment that's being proposed by Communication 132, you would have to post a sign saying that you are allowing the carrying of firearms within your establishment. And according to the bill as is, that would be both concealed and unconcealed permitted carry.
So I, as the business owner, and any business owner in our county would have to post a sign saying I allow it.
Yes.
And if someone comes in with a concealed carry and they have a permit and they're licensed to carry, what am I supposed to do? Because I didn't post a sign.
If you didn't post a sign,
Yep.
then it would, according to this ordinance, it would not be allowed, and it would be up to you to enforce that.
So now the business owner has to enforce someone with a concealed or open carry in their place of business because they didn't post a sign. It's confusing, but I'm trying to walk through this in my head of what I have to do now
Yes,
as a business
it-
owner. Someone enters my property to order food, and I didn't post a sign, but I'm okay with it. But now it's up to me.
Yes, but if you didn't post a sign and you're okay with it, then you should be posting a sign saying that you're okay with it.
That seems backwards. It doesn't seem like we're in tune with what the Supreme Court ruling was, which is it's okay unless states say otherwise, or unless a county says otherwise. In this case, we're saying it's not okay unless I, the business owner, says otherwise.
It is the fundamental right of the private property owner to make that decision, yes.
You can.
Okay, well, thank you. I don't like it when it's confusing. And to me, in this instance, on top of being, in my eyes, redundant as far as what places of public accommodation, as well as everything else we've listed so far, and then to go and say that unless it is conspicuously posted that they are allowed is backwards. That's what I'm gonna say this one more time. So you can carry a weapon, but you shall not carry a firearm in a place of public accommodation unless it's posted that it is allowed. Correct? Yeah, that seems backwards. I like the language that we had originally. That was my intent. And we got there after much deliberation. I would remind everybody. And now we are right back to our first argument. Our first discussion at our first committee hearing. And we're kind of circled back to the same language that we had a disagreement on in the beginning. So that's where I stand. Thank you.
Thank you, Mr. Connelly E. Kleinfelder. Ms. Kimball, go ahead.
Chair.
Oh,
Sorry.
wait, I'm going to go to Ms. Kirkowitz first.
Mahalo nui, Chair. I'm going to concur with my colleague, Councilmember Cornelia Kleinfelder, on this one. I'm not comfortable putting the onus on business owners to post signs that say you're free to bring a gun here. I think it gets businesses involved in the politics of this issue. And so I'm much more comfortable with the language that's currently contained in this bill. And so I won't be supporting this amendment. Thank you. I yield.
Thank you, Ms. Kirkowitz.
Thank you, Chair. First of all, I'm going to just respond with respect to the Supreme Court case. The Supreme Court case does not address specifically this notice on private property. What the Supreme Court addresses is the unconstitutionality of our state's concealed carry permitting process, and the fact that the process itself was not objective and required applicants to state the purpose for needing a concealed carry permit in order for self-defense. And so that's what the Supreme Court case threw out. The Supreme Court, through the majority decision and concurring decisions, left it up to the states and jurisdictions to identify what they wanted to call sensitive places. And schools, government buildings were clearly named. Other areas, they gave it, left it up to there being some sort of historical preference. So, you know, just some clarity around what the Supreme Court did and did not determine with their ruling. I want to just one more time appeal to my colleagues over there in Hilo, and I'm sorry I can't look you on the eye on this, but one of the reasons why I think it's imperative that we change the language to be a proactive, this is where it's permitted, is because we have historically not permitted it. And we had that conversation with one of our testifiers earlier today, that we have so many people that own places of public accommodations that are not even aware that we're having this conversation right now. And so they're, you know, when you talk about the number of signs that need to be posted, the probability is, the likelihood is that most places, if we were to keep the original language, would be posting language that says that it's not permitted. What we're asking for, what I'm asking for, is to consider that because of the historical prohibition or, you know, reduction of permits, the fact that this has not been widely permitted in Hawaii or Hawaiʻi County for, you know, all this time, is that we need to actually make it clear where it is permitted. And just to clarify something that Deputy Juan said, I think maybe it's just spoke too quickly there. It's not up to the business owners to enforce this. This is going to be law. It's going to be in the code, and it's going to be up to our police officers to enforce this. It may be up to the business owners, for example, to report it, but we're not expecting private property owners to go up and say, hey, you with a handgun, get out of here. Again, I think that this may seem like we're debating a somewhat irrelevant point, but to me, just because we have historically not permitted concealed carry in places of private business, I think for the time being, it is more important to give notice in the affirmative so that people are aware that this has happened. With that chair, I'll yield, but I hope that folks over in Hilo can consider this as an important change. Thank you.
Thank you, Ms. Kimball. Mr. Chung.
Yeah, just very briefly, you know, I wanted to say that Councilmember Kimball's description of that Bruin case is spot on. It really didn't have anything to do with, you know, rights to carry guns in different places. It merely related to the permitting process that was implemented or being applied in New York. But, you know, because we're anticipating the issuance of more concealed or carry guns, that's why we're kind of pressed into action. You know, but I certainly respect the will of the majority in, you know, in this case. But I just think, you know, having given it more consideration, I think what Ms. Kimball has proposed right now is a little bit more positive way of doing it, you know, where, you know, your firearms are allowed instead of having the establishment owner put up a sign saying not allowed. That becomes a little bit tougher in my opinion. But really it's the same thing, but I just think it's a bit more positive what's being proposed right now.
Thank you, Mr. Chung. Anyone else before we do a roll call on this amendment? Mr. Clerk, roll call, please.
On the motion to amend Bill 220, Draft 3, as amended with Communication 1022.132, Mr. Chung,
Aye.
Mr. Inaba,
Aye.
Mr. Connelly E. Kleinfelder,
Nope.
Ms. Kirkowitz,
No.
Ms. Kimball,
Aye.
Ms. Leloy, Ms. Villegas, Madam Chair.
Aye.
Madam Chair, you have 4 votes in favor, 2 opposed, and 2 absent. The 4 votes in favor, Mr. Chung, Mr. Inaba, Ms. Kimball, and yourself. The motion fails due to lack of majority vote.
Thank you, Mr. Clerk.
Chair, motion to postpone our rules so we can continue deliberation on Bill 220.
Thank you. Is there a second? Thank you, Mr. Chung. It's been moved by Mr. Inaba, seconded by Mr. Chung to suspend our rules so we can continue discussing this matter. All those in favor? Any opposed? We have 6 ayes, Mr. Clerk, and Ms. Villegas and Ms. Leloy are excused. Go ahead, council members. On the bill as amended. Go ahead, Mr. Chung.
Yeah, again, very briefly. Maybe I should give just my own thoughts about that Supreme Court decision. Okay, I think it was wrong, but we have to deal with it. And the reason why I think it was wrong, and what's pretty scary about it actually, is that the court went through this very circuitous historical analysis in coming to their decision. And I've always felt when you have to do something in that kind of fashion, it makes me believe that they came up with the decision prior to analyzing it. It's just my opinion. I think what's scary about it, because this type of analysis can be used in other types of cases. And when you deal with history, now we're dealing with a constitution that was developed, I'm thinking in like 1790 or something, the Bill of Rights, if I'm not mistaken. And a lot of things have changed since that time. So I think what they should have done was go with a strict scrutiny analysis and establish that there was a compelling state interest for them to rule in a certain way, because we have a different set of circumstances now with regard to guns and gun violence. And, Ms. Kimball had brought it up earlier, and I agree with her 100%. You cannot divorce the right to bear arms with the preceding sentence that deals with a well-regulated militia. Now, everybody's talking about the militia, but what I'm focusing on is regulated. And you just cannot divorce those two things. So it shouldn't be an unfettered right to carry guns, but it's really gone the other way. But it's just my opinion. But anyway, getting off that subject, I don't know how the votes are going to come down on this one, but I'm hoping that we pass something, because I was interviewed by one of the news people, and this is what I told them. When it was pointed out that our county is the only one that seems to be moving forward on something like this, for better or for worse, I just said that in that regard, I'm really proud of our council and my colleagues. Yeah, thank you.
Thank you. Thank you, Mr. Chung. Anyone else before we do the roll call?
Chair.
Mr. Connelly Kleinfelder.
Thank you. Miss Wan, there is a case, the Young case. And I'm going to stay away from certain aspects of it. Yeah. But the Young case interests me because it has been a case where a long-term court battle between an individual and the state over a concealed carry, like 10 years. But he's recently made progress in his case because of the Supreme Court ruling. So he's able now to go back his entire, and you stop me if I say anything that I'm not supposed to say, okay? But he's been able to go back for his entire court history now and ask for reimbursement for those court fees.
Deputy Corporation Counsel Sylvia Wan, as far as a request does not necessarily mean that that's a ruling. I mean, that a request like that can be made for any litigation where it goes the opposite way. But at the same time, that is not, the Young case is not dealing with any of the matters that are before this body right now. It has to do ultimately with the 134-9 statute, as was as currently stated, and is currently under review because of Bruin. It is separate and apart from the sensitive place prohibitions that the council is deciding right now. So it is not, I mean, I understand how they might seem like they're related, but they are actually not related.
Okay, and it's the same thing that Corporation Counsel Ms. Strand said.
Yes.
But what concerns me is that he was in court for a number of years. And then he was actually able to go back now and request compensation for his court fees over the last 10 years, despite the ruling happening in the last year. And that concerns me when it comes to what we're doing. And if anyone has a court case out there and they decide, hey, the Hawaii County's ruling was, the law was unconstitutional, and they've had a 20-year court battle over something similar, and all of a sudden we're in their crosshairs and we've got a deep pocket. And I am concerned about that. I just want to say that it was unexpected for me to see someone's 10-year litigation all of a sudden have a fruit because of the Supreme Court ruling. That to me was unexpected, and it's concerning because as we pass laws, if someone's been in litigation for a number of years, they could say, oh, well, now I have grounds.
I understand where your concern is stemming from. However, that is not quite how it works. The Young case is unique. As far as his requests, I cannot comment on the validity or strengths or weaknesses of that request. And my understanding is that still is pending, and that has not been ruled on, whether that request has been made or anything to that effect. As far as being concerned about things like that, I think in this particular perspective, you cannot allow the idea or threat of potential litigation that could happen over anything to really shadow or shade what is the current state of law and what is currently allowed. Because 134-9 was allowed when the Young case started, and it is only today. And the only reason why he might even have any potential anything is because he was still pending appeal. So that is a very unique circumstance that I do not think is the norm and should govern what this body decides.
Okay. Is there any litigation or case law that you're aware of that could put us into potential crosshairs for someone who has an existing case who's going to say, oh, this applies and I have a window now?
Deputy Corporation Counsel Sylvia Wan, as far as this particular litigation, this particular bill and ordinance that is being contemplated by this body, I am not aware of anything that covers this particular avenue.
Okay. Thank you. Well, we've had a lot of discussion to date. I think ultimately I will be supporting this today. The last amendment I did not support, and with reason, but I've had a number of people reach out to me, and Mr. Ruderman's testimony this morning was, I think, covered by what we've done to date in this bill. I really do go back and forth on this, and I do feel that we may open ourselves up to some form of litigation in the future, but it seems like for the majority of the public, although they are not here, I think this is a positive, so I'll be supporting today. Thank you.
Thank you, Mr. Connolly Kleinfelder. Anyone else before we take the roll call?
Chair.
Thank you, Ms. Kirkowitz. Go ahead.
Thank you. I'm not going to be supporting draft 3 today. I had expressed concerns about the first draft being overly prescripted and not in alignment with the Supreme Court's decision. And so I know a lot of really great work happened in committee, which made it much more palatable to me. And this is a hard decision for me to make because we're really trying to thread the needle here to ensure that we're upholding citizen rights, but also making sure that our communities are safe and our citizens are protected. And so I just can't support this current version that's in front of us. Thank you. I yield.
Thank you, Ms. Kirkowitz.
Yeah, I just wanted to make a few concluding comments here. First of all, thank you, Mr. Chung, for your analysis of the Supreme Court decision. I tend to concur. But one of the things that we've said here is that this is a stopgap measure until such time as the state legislature introduces their own. And my understanding is that there are discussions going on, and it is likely, if not probable, that they will. However, I think we should also take into the account the possibility, unlikely as it may be, that the state will leave it to the counties to do this. And so basically, there's two things here. One, if we don't pass something now, we have at least until the middle of the summer next year before there is something that will be on the books from the state because it's got to go through the legislative process. And two, there's the remote possibility, given that we are working on this, City and County of Honolulu is working on this. I know that there's interest in Maui and Kauai to develop their own again. That there is a possibility, no matter how remote, that only that the state could leave this up to the counties entirely, in which case we would be left without anything. So I appreciate the hesitation. I think we are well within our legal rights to do this. Again, want to thank Councilmember Chung for initiating this conversation. I think we've, through very lengthy discussions, developed a very high quality bill that's been well thought out, highly defensible, and just encourage everyone to lend their support today. Thank you.
Thank you, Ms. Kimball. And if there's no one else, I just want to say my mahalo to Mr. Chung and to Ms. Kimball, because I think between the two of them, they work very hard in getting this bill to the point where we are now going to be voting on something almost as good as it can be. Mr. Clerk, roll call, please.
On the motion to pass Bill 220, Draft 3 as amended on second and final reading, Mr. Chung.
Aye.
Mr. Inaba.
Aye.
Mr. Connolly Kleinfelder.
Aye.
Ms. Kirkowitz.
No.
Ms. Kimball.
Aye.
Ms. Leloy. Ms. Villegas. Madam Chair.
Aye.
Madam Chair, you have 5 votes in favor with Ms. Kirkowitz voting no, Ms. Leloy and Ms. Villegas absent. The motion carries.
Thank you very much.